How do you contest a will with suspicious changes? Imagine discovering that a will has suddenly been altered in ways that seem odd or out of character. You might wonder if someone tampered with it or if it's truly valid. When you suspect suspicious changes in a will, it's important to understand the legal steps involved. First, you cannot challenge a will until after the person who made it, called the testator, has passed away and the will has been filed for probate. Probate is the court process that confirms the will's validity. To contest the will, you need to find solid legal reasons that question its authenticity. Common grounds include undue influence, which means someone pressured the testator into making changes they wouldn't have otherwise. You must show evidence that the person was manipulated or coerced beyond normal persuasion. Fraud or forgery is another reason. If you can prove that the signature was forged or that someone tricked the testator into signing a document they didn't understand, that can invalidate the will. Lack of mental capacity is also a key issue. If the testator was not mentally capable of understanding what they were doing when they made or changed the will, it can be challenged. Improper execution refers to changes not following legal rules, like not having the right witnesses or signatures. To build a case, gather evidence such as medical records showing mental state, witness statements about how the changes happened, or forensic analysis of signatures. Financial records or communications might also reveal manipulation. Once you have your evidence, you need to file a formal petition with the probate court, explaining why you believe the will or its suspicious changes are invalid. The court will then review the case, and both sides may exchange evidence during discovery. Sometimes, parties try to settle disputes through mediation to avoid a lengthy trial. If the case goes to court, a judge will decide whether the changes are valid or not. The judge might declare the will invalid or order the estate to be distributed according to an earlier valid will. Remember, there are strict deadlines for filing these challenges, often within a few months after the will is filed for probate. Missing the deadline usually means losing the right to contest. From an estate and elder law perspective, it's especially important to act quickly if you suspect someone was vulnerable or under undue influence when changes were made. Consulting an experienced attorney can help you understand your options and guide you through this complex process. Always keep in mind that challenging a will is a serious legal step, so gathering strong evidence and acting within the proper timeframe are key to protecting the true intentions of the person who made the will.